So our panel is going to join us on stage here. We have an amazing opportunity to hear from the tribes that have been part of the pilot project to exercise this jurisdiction. Go ahead and come up and join me on stage here. Come on up. This is I've been looking forward to this for months, so I'm all verklempt already. Okay, so as everyone's getting on stage here, I'm going to get a little law professor here for just a second. Just give me 10 seconds. Congress didn't give us anything. They restored what they took away. Nobody gave us this authority. We never relinquished it, right? So now let's hear how we're restoring it. And we're very lucky here. We're going to have our moderator, Steve Aycock, who is the judge in residence of the National Council of Juvenile and Family Court Judges. And he, until 2008, was the Confederated Tribes of the Colville Reservation. And he was chief judge at the Colville Tribal Court for 9 years. And he has a great bio. You should check out in the back of your program. But I don't want to take any more time away from this. These are the people that are doing the work to make VAWA real. And I'm so proud to be part of this. Judge Aycock, you're right here. Okay, let's get started.
Thank you, Sarah. Let me just say how honored and humbled I am to be able to stand here, not only in front of you, but with these wonderful people off to the left, as you just heard. So as you just heard Vice President say, there are 3 tribes that are already exercising this criminal jurisdiction. These are representatives from those 3 tribes. I'm going to get out of the way and let them talk. So, Brent, you want to go ahead from Umatilla?
Sure. I'm going to try to give you an update on everything in 10 minutes. So, actually, I'm going to give you a brief history of Umatilla Tribal Court, Modern Court, in 10 minutes to get you up to date. But to begin with, there are 3 cases pending right now, or 3 cases at Umatilla, non-Indian domestic violence cases that have been prosecuted. There have been 2 convictions, and 1 case is pending that has multiple serious felony charges. So it's being done. But to understand how to get there, and I think you all can get there too, let me give you a brief history of Umatilla Tribal Court. Oregon is a mandatory PL2A state, which means the federal government in 1953 gave the state the jurisdiction over crimes and civil matters on the reservation. The result of that really was that the tribe didn't have resources to be able to run its own criminal justice system. It was dependent on the state. And lo and behold, the state didn't come out and do much anything other than harass tribal members, prosecute tribal members, and didn't do much regarding non-Indian crime on the reservation. And about half the reservation is non-Indian. So the tribe fought hard to get retrocession, and they succeeded in 1980. Governor Taya retroceded criminal jurisdiction, not civil, criminal jurisdiction to the federal government, which meant the tribe finally got resources to start its own criminal justice system, active criminal justice system. And how that came about was Judge Johnson, who's current judge, tribal member, member of the Oregon State Bar, was a young attorney at that time. Doug Nash was an attorney for the tribe at that time. They found out in a Federal Register notice that retrocession was going to happen. And lo and behold, they found out they got 2 weeks to put together the court. So they did, and they developed a criminal code that largely reflects a lot of the language of Oregon statute on crimes, some of the procedures and process, including juries, which I'll get to in a little bit. But it started out with Judge Johnson on a card table in the gym. Judge Johnson was prosecutor, the defense attorney, and the judge. That's where we started. Not there now, so it can be done. Over time, the tribe really devoted resources to expanding the criminal system, the court system, and over time, they got a prosecutor. The prosecutor is a law-trained judge. Current prosecutors, tribal member Kyle Daly, also a member of the Oregon State Bar. They have defense attorneys who are law-trained defense attorneys. Right now, we contract out defense work to local attorneys. Everybody gets effective assistance of counsel. At Umatilla, anybody who wants counsel can get counsel free. Unlike in the United States or state systems, you don't have to be indigent. Judge Johnson will appoint somebody if you want one. So and all the laws have always been available to the public. They're online now, and all the proceedings have been recorded. So, tribes in 2006, 2007 really tracked what was developing in Senator Dorgan and the Tribal Law and Order Act, because we really want the power to be able to do felony sentencing, prosecuting misdemeanor, rape, attempted homicide is disgusting. The ability to get some justice out of that by doing felony sentencing was important. So we did that, and it was fairly easy because tribe was already doing everything. We just needed to make those rights explicit in the code. We did that and went through the various criminal statutes and identified whether they're misdemeanor or felony, did that. And right now, we implemented felony sentencing in March 2011. We've had many felony prosecutions, many felony convictions. We got 3 people in federal prison on tribal charges right now under the Bureau of Prisons pilot project, which sunsetted last month, needs to be expanded and made permanent. So that's where things were at until VAWA 2013. We're very much involved in that and excited about that. VAWA 2013, after 500 days of fighting to get this passed in the face of people saying that non-Indian crime didn't happen on reservations against Indians and that non-Indians can't get a fair trial in tribal court, which I think Pascua Yaqui recently proved false. We were able to do that. One of the additional requirements for VAWA 2013 is to have non-Indians on jury pool. This gets back to what I said a minute ago. When they adopted the code originally, tribal criminal code originally, the jury pool is made up of any resident 18 or older on the reservation. Didn't say tribal member, didn't say member of another tribe or anything like that. And for a while, they didn't have non-Indians on the jury pool until one day a tribal member complained that she was having to serve on jury pool and non-Indians didn't have to. And that tribal member happened to be the judge's mom. So that changed. That changed a while ago. Now the tribe's jury pool is made up. We get a voting district that's a rough overlay of the reservation from the county, and we use that in 5 minutes. And we use that to impanel the jury. So did that. We also have to give additional habeas corpus rights notices. We did that. It was fairly easy to meet those things because we already had. What we then had to do was go back and amend the jurisdictional section to include non-Indians, amend the complaint section to require the jurisdictional elements when filing a complaint, and amend the defendant's rights section. So in the process of doing all of this, the tribe did it so that everyone gets those rights. These aren't rights for just non-Indians. They aren't rights for just felons. Everyone, regardless of crime, regardless of seriousness, has these rights. Which brings me to the next point. I've heard criticism of VAWA 2013 by people saying that they think this is an attempt at jurisdictional assimilation, trying to make tribal courts federal courts. And I want to point out, as Judge Johnson often says, that isn't the case at Umatilla. At Umatilla, what's happened is that the tribe is giving the same rights to non-Indians as they give to their own tribal members. That's how it works at Umatilla. This isn't assimilation. And I want to point out, we've got 3 cases. The other tribes have a number of cases pending. Non-Indian crime does happen on the reservation, as I'm sure you're all aware. I remember back in 2010 being at a breakout session here when I believe it was an FBI agent had mentioned that there was 1 crime registered in the Lion system showing that there was non-Indian on Indian DV crime in the entire nation. Of course, at that time, I think there was 1 or 2 cases that I was well aware of at Umatilla alone. This has proved them wrong. They're just dead wrong. We're prosecuting them. They are there. They're finally being taken care of, and this is just 3 tribes. And the other thing I want to say is that for those who said that defendants can't get a fair trial, they clearly can, they clearly do. The first case we had that was an assault, domestic violence, it was a great case, well investigated. There was a confession involved. He got a protection order put in place, and while the case was pending, he violated that protection order, and got held in jail pending trial. Lo and behold, he decided he wanted to plead guilty. He did, and he got sentenced to that. But in that process, we encouraged him quite strongly to appeal the case to federal court to challenge jurisdiction, because that needs to happen. And this was a perfect case and vehicle to do it. Unfortunately, he declined. He'd rather be in tribal court. He'd rather get tribal justice, which is probably lighter than you get in the federal and state systems, and he's perfectly happy with the tribal system. He is also one of the first people in our domestic violence offender treatment program. So we just started that up recently, and one of the first people is a non-Indian. So that's what's going on at Umatilla right now.
Thank you, Brent. That's Brent Leonard. He's the reservation attorney at Umatilla. And Fred, are you going to go next then? This is Fred Urbina from Pascua, Yaqui.
Good morning. We don't have too much time, so what I'm going to do is quickly go over some data, and then OJ will take over and touch on some specifics about our cases. It's important to start that for the Yaqui people, the first contact with non-Indians was 1533. They've been wanting to hang out with us ever since. So, and so, since VAWA jurisdiction started, we've had a total of 18 cases on the reservations. The cases involved 15 defendants, 3 who have already reoffended. We have had 4 convictions thus far and 1 jury trial. We have a total of 14 female victims and 1 male victim involved in a same-sex couple case. Most of the female victims are single mothers who reside in tribal housing. Most of the offenders have extensive criminal records in the state of Arizona. 3 had warrants, 2 were felons with convictions for burglary, and 1 was wanted in Oklahoma for armed robbery. 4 of the crimes were serious enough to warrant referrals for federal prosecution for allegations of strangulation, aggravated assault, etc. The average VAWA offender were contacted by tribal police at least 6 times prior to us having this jurisdiction. In total, there was a total of 84 tribal police contacts pre and post VAWA for each of these offenders, where most of those contacts we couldn't do anything about the crime they committed on the reservation besides take them off the reservation. 11 of the cases involved children in the home. There was 18 total children involved. This VAWA does not extend to children, so we can't prosecute for crimes involving children. So we had 18 total children ranging in age from infancy to 11 years old, with the average age being 4 years old. All of these children exposed to violence. Some were victims, they had been physically abused. Some were removed and placed into the child welfare system. When you count the children and the number of victims in these cases, the total is 32 folks that were either subjected to violence or witnessed violence. If you think about the numbers, and if you think about the 566 tribes, recognized tribes that could possibly exercise this jurisdiction, and he extrapolated those numbers and averaged and said that maybe each tribe averaged 15 to 20 cases, you would have at least 8,000 to 10,000 cases in the short period of time from February to November in Indian country. So think about the numbers. Those other crimes are occurring. They're happening now on your reservations. They're happening while we're here today. So yeah, it's been 9 months. 9 of the offenders were living in tribal housing. This raises issues of tribal housing policies. 7 of the offenders are of Hispanic descent. 2 are legal permanent residents from Mexico, which raises issues of deportation upon conviction. Also, do you have interpreters in your court for these types of cases? Tribes in California, New Mexico, Arizona would have issues like these issues that we're dealing with. 7 of the offenders had previously been arrested for violent crimes, weapons, or threats. 6 of the incidents involved alcohol. Only 3 offenders did not have a criminal record in Arizona. 10 of the offenders had previously been arrested for cases involving drug use, possession, DUI, or alcohol. And I'll turn it over to OJ, and just a little bit about the jury process. Our judge is Lakota. The tribal prosecutor was Yaqui. The tribal jury is majority Yaqui, with one non-Indian sitting on that jury, and he ended up being the foreman, an African-American employee of the tribe.
Okay, now I'll just touch base a little bit about the trial, because as most of you are aware, the opposition for the jurisdiction, for tribal court jurisdiction, was based on the fact that non-Indians wouldn't get a fair trial. And as Brent mentioned, that couldn't be further from the truth. In fact, our jury trial actually didn't even determine guilt, because they felt that there wasn't insufficient evidence to determine a dating relationship. The reason for that being, as Fred mentioned, we had a same-sex case involving 2 males within our reservation, one of them being non-tribal. An African-American male who was hiding out on our reservation for a warrant he had out of Oklahoma for armed robbery. So a little bit about that case itself. The victim, who was an older Pascua Yaqui tribal member, took this younger African-American male into his house, and they had what everybody in the community knows was a relationship. However, they couldn't articulate or explain how or why they knew that was. And that turned out to be the issue that the jury just weren't convinced beyond a reasonable doubt was sufficient to say everybody knows, but we can't tell you how. But what was absolutely clear, and everybody completely understood, including the jurors, because we got an opportunity to speak with them after the trial, was this African-American male absolutely brutally attacked and assaulted the Pascua Yaqui tribal member. In fact, the photographs that we used during the trial show the blood splatter on the concrete where his head bounced off the concrete when he attacked him. The photographs showed the blood splatter from the defendant's hands as he walked away to try and hide in the room where he was found. There was blood trails dripping through the house into the room where he was hiding. And when they arrested him and they took photographs for evidence that was going to be used in trial, the photographs still show blood dripping off his hands at the time that they took him into custody. And so what occurred there was that within this relationship, the victim walked home from his nearby family residence and was walking to his house within the reservation. And they got into a verbal argument in the street, and one of our law enforcement officers noticed them, stopped them, and intervened before something worse happened. The defendant, who was 20 years old at the time, was seen with an open alcohol container, got cited for minor in possession of alcohol, and eventually they all went on their way. The defendant went to the house about 20 minutes later, and he thought in his mind that the victim called the police on him because of their argument in order to get him arrested or cited for having the open alcohol container. That was what triggered him to assault him, because he thought he called the cops on him. That's what led to him having the wounds on his head. That's what caused the wounds to his arms, his legs, his nose, and forced the victim to go to the hospital. And just to add a little bit more context to what Fred was talking about with some of these numbers and how we can extrapolate this to the entire tribal community. All of this happened within our Pascua Yaqui reservation, which is 2 square miles. And when you think about that in the context of some of the reservations that are quite larger than that, you can imagine some of the things that our tribal communities are worried about, and rightfully so. And at the end of the day, the congressional leadership needs to understand this stuff is happening in our tribal communities, and it is something that we're capable of giving people a fair trial at. Thank you.
And I'm now going to turn it over to Judge Pouley from Tulalip Tribes.
Good morning, everyone. Tulalip's got this whole half of the table here, and you got to hear from our board member this morning. Exercising extended jurisdiction under VAWA absolutely, positively takes a team. All the participants of the tribe. I'm so honored and humbled to be the Chief Judge of the Tulalip Tribes. But Tulalip also honors its history first. So just like we honored these blankets this morning, we're going to talk about the history of the tribe, and that's going to be done by our Chief of Police. We're going to talk about how our laws and codes to exercise this jurisdiction were set up and the hard work of all the participants that went in. And then we're going to talk a little bit about where we're going to go from here. So with that, I'm going to turn it over to Chief.
Hello, my name is Carlos Echevarria. I'm the Chief of Police of the Tulalip Tribal Police Department in Washington State. Tulalip has 22,000 square acres, and we have jurisdiction over all those tribal lands, as well as our usual custom hunting and fishing areas. Our population is 15,000, 12,500 non-natives, and we have 2,500 tribal members that live on the reservation. We also have 75,000 visitors daily to our business park and to our other tribal businesses located throughout our reservation. Our police department is made up of 37 commissioned officers, and I have a staff of just over 50. There's 3 obstacles that the Tulalip Police Department has faced throughout this process. The first one is lack of funding with regards to incarceration of these perpetrators of domestic violence against our women. The costs grow rapidly daily, and so I believe that Congress is putting forward some funding sources to further assist not only just the pilot project tribes, but the other tribes that decide to implement this moving forward in 2015. The second is, until there's a complete reversal of the Oliphant decision, tribal nations, tribal police departments, tribal justice systems cannot fully protect our Indian communities and tribal communities across the United States. We must have that. And lastly, there's a number of tribes in California that are represented here today. As a tribal police department in Washington State, I do not have access to criminal history from the state of California. This has been an ongoing battle. It needs to be changed, and I stand with you in anger and frustration for my officers and for the protection of our communities. The fact that this is still continuing in 2014, by all means, I'm just speechless that this continues and occurs today. I wish I could speak more on this topic, but I'll leave it at that and forward it over to the group.
Tulalip Tribes is a tribe of about 4,500 members, and we've been prosecuting non-Indians exactly the same as we prosecute Indians. And all of you should tell all of your Republican friends or foes, the sky did not fall in. So the prosecutions are absolutely unremarkable. Just like Judge Johnson at Umatilla, those 5 cases are processed exactly the same as we process it for our Indian clients. We 100% believe in due process of the law. We follow it every day, have for a decade, and we continue to do that with our non-Indian participants. So all of it has been really unremarkable. We also have planned and prepared for a variety of appeals and habeas corpus, because you should always be prepared, right? That's the wisdom from our ancestors. And a little bit like Brent, everybody wants to stay in tribal court. So I'm here to tell you, work hard, follow the law, but you know, for the 5 cases that have been filed, those are 5 voices that never were heard before, so it's worth all the hard work every day. And I'm going to turn it over to the prosecutor who does that work for Tulalip.
Okay, I have like 2.5 seconds. My name is Sharon Jones-Hayden, and I'm honored to be the Domestic Violence and Sexual Assault Prosecutor for the Tulalip Tribes. I expect that the scene at your reservation or community was the same as at ours on the day we got word that VAWA had passed. Lots of hooting and hollering and some tears and celebration that this had finally come to pass. The first arraignment hearing that was held with a non-Indian defendant, I turned around after conducting this absolutely unremarkable hearing to see the gallery in our courtroom packed. It was full of people. It was full of grandmas and aunties. It was full of people who just wanted to be there for that historic moment. It was a very routine hearing. There was nothing extraordinary about it, but it was huge in so many ways that I know you can understand. Of course, once we began to move forward into implementation, we began to realize that, as the Vice President said and as others have said, that this statute is a tiny little down payment on a long overdue correction to the problems that we face in keeping our community safe and in prosecuting these cases. As Judge Pouley mentioned, we have had 5 cases in our court. 2 have resulted in convictions. 1 is set for trial next Wednesday. But those gaps that we are recognizing as we begin to move forward have to do with those collateral crimes. Others have mentioned the fact that we had kids involved in all 5 of our cases. Sometimes they were witnesses, other times they were victimized. That victimization has never been able to be addressed in our court, the victimization of those children. 2 of the women were pregnant at the time of the assault. Those of you who work in this field know that that's a common occurrence. And 2 of the incidents involved rape. Those sexual assaults are not able to be prosecuted under VAWA either. So all I'm saying is there is great joy and anticipation of beginning this work, but there is much, much more to do. Judge Pouley's watchword is unremarkable. These cases are completely unremarkable. They're just like every other case that we handle. And in the sense of the process that we've undertaken, that's true. And I think it's very important that that message be loud and clear to the dominant culture, that these are unremarkable cases in every way. In fact, I'll have to tell a story. I don't even know if other people in our team know this, but we entered a plea in a VAWA non-native case, and the judge, not Judge Pouley, another judge that heard the case after the hearing was concluded, several days later said, "Why didn't you tell me it was a VAWA case?" Even to the judge, it was so routine in that sense that there was no difference. But I have to say that it is remarkable in many ways, and it's the survivors that Aaron and I see in our office every day who come to us amazed that their stories are being heard, their voices are being heard, and that justice is being done. And so the process is unremarkable, but the impact on our community has been remarkable.
Good afternoon. I have 1 second, and so what I'd like to say is, as my colleagues have said, it's unremarkable how these prosecutions proceed, but the impact is so incredibly meaningful. We have so many victims that are being served and that are trusting the justice system for once in their lives because their voices are being heard. When we first received notification that we were going to be granted a pilot project status, we implemented in February. Within a week, we were not prepared for the media flood that we received. The world was watching. France, Al Jazeera, other European countries were contacting us frequently, wanting to get just as much information as they could about the process. In terms of, this is, and why was that? Because this was groundbreaking legislation that recognized the inherent authority of an Indian tribe to prosecute bad guys. Inherent authority. That is so important. It wasn't a grant of authority, it was inherent authority. So feel that. Feel it throughout you as you're doing these prosecutions or trying to convince your leaders that this is really important work to be done. I just want to say that we still have a few challenges. We need to be able to prosecute on behalf of the victims, the children victims. Those children victims that have been in these prosecutions, those crimes are going unpunished. NCIC, we may be able to prosecute protection orders, but Director Comey, we need to have direct access to entering these protection orders ourselves. We should not have to go through the state in order to do that because it creates barriers for our people and for the protection of our women. And finally, we need money. CTAS, Carol Mason, I realize she's not here today, but please consider adding another track to the CTAS that provides for the implementation and funds the $5 million per year as Congress envisioned in this law. We need that money. It costs money to do this. And so please take that message back to Ms. Mason. And I'll turn it over to Judge Pouley. Thank you so much.
Well, I'm just so proud of these people, and I'm proud that I've been able to work with them for the last year or so and call them friends. These are your warriors who are out on the front lines who are already doing this, so let's give them a huge round of applause. And just one final word, come March 7th of next year, you all can be doing this. Do so carefully, thoughtfully, and feel free to contact any of the people up here. Contact NCAI, TLPI, the National Council of Juvenile Family Court Judges, and we'll see what we can do to help you and connect you with resources to get this done. Thank you very much.